Can I automatically sue for legal malpractice if my attorney made a glaring error? Attorney Tommy Pittenger explains. Often, clients will review their former attorney's actions with the full benefit of hindsight. However, to determine negligence, you must put yourself in the attorney's shoes when his or her mistake happened. Decisions that felt reasonable at the time might now look foolish in hindsight. Attorneys are required to act consistently with the local community's standard of care. Not every mistake rises to a breach of that duty of care. Even when an attorney makes a very obvious mistake, that mistake is required to have injured the client if a legal malpractice case is to exist. One very standard example of negligence is an attorney failing to file a lawsuit before the statute of limitations expires. Even if this is considered an inexcusable error, it only gives rise to a legitimate legal malpractice claim if the client can prove to a legal certainty that he or she would have won the case in question, had it been filed in time. The client must also prove just how much money he or she would likely have won in the case, and that the judgment was actually collectible. Legal malpractice cases are considered to be rather expensive in comparison to other cases because you are basically litigating two cases at once. In addition to typical legal fees, you will nearly always need an expert to help establish that the attorney's conduct indeed fell below the community's standard of care. Tommy Pittenger has more than 20 years of experience practicing law, and he is passionate about helping clients who have been improperly represented by their lawyer.